I'm unsure at all about what Amos is talking about when he's talking about thousands of detainees who will be subject to trial. I really have no idea, and I didn't have a chance to talk to him about that. The United States has no jurisdictional basis to try these individuals outside of the United States, and the United States, as someone has indicated, has said that it's not their intent to try these individuals. So as Bob says, the number of detainees in issue really is a fairly limited number that we're talking about, and I think that we can do it with Article 3 courts. It goes without saying that this means that we have to close Guantanamo. Now, there have been any number of studies done on this. Human Rights First, as Gabor indicated, has done a very thorough study. The Center for American Progress has done a very thorough study on that. They take it from the first week right through the first year as to what can be done. There are problems, there are obstacles with respect to how you prosecute the really bad guys, but I would rather wrestle with that particular problem than continue to have Guantanamo as an albatross around our neck. This means that this will end the CSRT process, and here I'm getting into more definitive recommendations. I would terminate completely the military commission process. The military commission process was a mistake from the beginning. I've used these words before, and I'll use these words again. The military commission process has bastardized the military justice system, and it has prostituted the military attorneys forced to attempt to make this system work by political appointees. The only reason that the military commission process is constituted the way it is constituted is because it's the only way that we could successfully prosecute and convict individuals against whom we had used coercive interrogation techniques. The military commission process has to go. That means that you have to rescind the military order that established the military commission process. You have to repeal the Military Commissions Act. There's no way that you can fix the Military Commissions Act. It's replete with too many errors. You need to repeal it and go back and return many of these provisions to the status quo. You have to amend the Detainee Treatment Act. There are problems with the Detainee Treatment Act as well. The Detainee Treatment Act establishes a dual system for the interrogation of detainees in sections 1002 and 1003. One for DOD, 1003 for CIA. We don't have time to get into it, but that particular regulatory system depends on violations of the 5th, 8th, and 14th Amendment. That's the shocks the conscience of the court standard, considering all the circumstances, and that is broad enough to drive a truck through, and that's what the Central Intelligence Agency has done. You have to withdraw Executive Order 13440. We've talked about that before. That's the executive order that flows from the Military Commissions Act, the one in which the President was supposed to define the interrogation techniques that could be used by the Central Intelligence Agency but still comport with Article 3.1c. Of course, it does not do that. It simply justifies prior decisions made by the administration and qualifies interrogation techniques. In terms of commission to a truth commission, for a lack of a better term, I think that we should establish a bipartisan commission to examine what was done, what laws need to be repaired, what statutes need to be amended. I have been contacted by any number of people saying, would you join us in urging the prosecution of individuals who have provided bad legal advice? I'm not one of those who supports attempting to prosecute individuals. I'll leave that to the international community if they want to assume that. Now, why do I say that? Because I think in order to achieve all the other things that I recommended, we're going to need a great degree of bipartisan support. And I think if you start to go after individuals in any kind of truth commission, you're going to lose that bipartisan support. And I think the good of the whole is better than the prosecution of a number of individuals, at least from a U.S. domestic perspective. All right, that's from the macro to the definitive, and I think I'll end there, Tom.
Do we have any questions? Oh, yes, Mary Ellen.
David, we just disagreed on this one last point. Sorry. We just disagreed on this one last point about prosecutions. I mean, otherwise I think we were very, very close in our points. And I'm just curious, do you feel that the United States does not have an obligation under the Geneva Conventions to prosecute those who violated, who committed grave breaches under the third or fourth conventions?
I think certainly in the case, well, you don't have to, I think we do have an obligation. I'm not sure that you have enough evidence available to you to demonstrate that those grave breaches occurred. And I think the damage that would occur, Mary Ellen, in trying to achieve those prosecutions would rob us of the bipartisan support that we need to right the many things that need to be righted. To include a revision of legislation, to include repeal of the Military Commissions Act, withdrawal of the executive order, which establishes, which I did not say, establishes one standard for interrogation and treatment. That's the standard that was set forth in FM 34-52. 222.3 may have some problems, but there should be one standard for everybody, and I've never been convinced by anybody that we shouldn't have one standard. So I think, yes, if you could demonstrate that the violations have occurred, there definitely is that obligation under the conventions. I'm just not sure that we're at that point, Mary Ellen.
I agree with that.
Of course, there's a halfway house. You could bring back stocks and throw rotten tomatoes at them for a day. Would you go with that?
I told you he was British.